Okay, good evening to everybody. This is Akol Podcast, the Boys of Innovation. Today I'm here with my brother Molana. We are going to discuss a lot of things. Good evening, everybody, and welcome once again to Akol Podcast, the Boys of Innovation. My name is Akol Miyuen, and today we are bringing a very important national discussion that touched the foundations of constitutional development, identity, and even peaceful coexistence in South Sudan. Today, we are going to discuss two sensitive and critical issues that continue to shape public debate across the country. And the first issue is the English language, the one that we have seen last week, where the Chief Justice, Dr. Benjamins, has released a circular, and that circular was to allow judge to make verdict in English language instead of Arabic language being monopoly in the justice sector. The first issue is the use of that, and also writing verdicts, as I said earlier, within the judiciary and legal system of South Sudan. Seen independent, we know that South Sudan adopts English as the official language and partly has a political and historical transition from Sudan. However, many South Sudanese continue to ask difficult questions regarding accessibility of the justice, understanding and inclusiveness within the legal systems. A very important concern today is whether ordinary citizens truly understand the legal decisions and court verdict written in English. In many communities across South Sudan today, people communicate daily in Juba Arabic and local language, even within court, police stations, and public institutions. So all these things we used to see them. Arabic still remain one of the most widely used language for communication in South Sudan. And this raised a major constitutional and practical debates. Can justice fully be delivered if the majority of citizens cannot easily understand the language used in legal proceeding and verdict? Should Arabic continue to play roles within the legal system alongside English? And how do we balance national identity, legal professionalism, and public accessibility without excluding sections of society? And language is not only about communities. Language is a connected power, and that's why we have our brother here today, and we are going to digest these two topics. And another topic is going to be the land tenure and who own the land. Is one of the major things that most people discuss, and most people have been talking about this long time, and we don't know who owned the land in South Sudan. And maybe our brother is going to illustrate more about that. And we warn you also, if you have a question, maybe you can just ask the questions, and my guest here is going to answer them accordingly. We want to know who owned the lands as well, and how can you access the land? How can you own the land in South Sudan? Does land belong to community, or the land belong to people of South Sudan, or it belong to the government? And I believe I talked about this last week, where there are a lot of contested visions about this, and all these visions they are contestings, and all of them they carry a weight. So I don't know. My guest here is going to explain more about that, and I want to give him this floor to answer some of the questions that I'm going to ask as well. Welcome on board, Molana. Why did South Sudan adopt English as the official language today in South Sudan? Why does South Sudan adopt this language to be a national language? Thank you.
Uh, Thank you, my brother Akol Maunatian, for inviting me on your podcast of today. And I'm very happy for the first time for me appearing in your show regarding the issue that we are going to be addressing, the issue of why is the South Sudan not using English language, which has been stipulated by the Constitution and the recent circular issued by the Chief Justice. And we are going to discuss also the issue of land tenure, who own the land, and how can you access the land as an ordinary citizen, whether citizen or not citizen. We are going to explain them out. And to begin with, today is a special day for us as a country. We are celebrating 16th of May. We are remembering our heroes and heroines who has died, and the reason why they have died is the reason why we get the freedom of us being an independent nation today, they did not die in vain. And thanks to the liberators, those who have died and those who are still alive, may God bless them all. And thank you for having me.
That's good. That's good. Angelo Luol, thank you so much for being here. And we are going indeed to digest more about these two critical questions. And I think they are very sensitive. And that's why you see when people try to debate on this, so it doesn't end at all. People keep talking about this. And I want to know from you as experienced lawyer, Angelo, so why does South Sudan's government adopt English as a official language in South Sudan?
Yeah, the reason to regard why South Sudan adopt English as the official working language in the Republic of South Sudan is, according to the recent circular issued by the Chief Justice, is correct by the law. And according to Article 6, Clause 2 of our transitional constitution, make English as an official language in the Republic of South Sudan. And may you give me the floor so that I may read, because ours we are referring with the article and supporting you. We don't make things out public.
Okay, that's good.
Yes, thank you. Article 6, Clause 2 is saying that English shall be the official working language in the Republic of South Sudan, as well as the language of institution at all levels of education. That is where the English get its power from, as an official language being declared by the Constitution, which is the mother laws of all laws. And where the contradiction come in from this civil procedure, the one I have in my hand, under Section 66, and I may read also for the viewers to see the contradiction within the law of South Sudan, that there is a conflict of law. You see the Constitution is saying this one and the other law is saying something, and we shall see which law, what if two laws are conflicting, which one can prevail over the other one. Section 66 of the Civil Procedure Act 2007 saying official language of the courts. The official language of the Court of South Sudan shall be English and Arabic, but the court may hear parties or witness who are ignorant of English and Arabic in any other language through an interpreter on oath, subject to any law providing of or certain localities. That is what the law is saying about this one. The civil procedure has empowered the
Okay. Now, but how do you differentiate these two laws, civil procedures and the act? How can you differentiate them? Because now you see, we are seeing witness being involved, and if they don't know Arabic, okay, I mean, if they don't know English, or if I open a case against someone, like I open a case against you, Angelo, I say that maybe I have a case with you, and we went to the court together. And I opened that course, and I don't know English language, and I want to access my justice. Maybe you have taken something from me. How can I communicate to the judge?
Yeah, I think that one, there is a conflict of law, as I have narrated before, Ali, of which the Constitution and the civil procedure, plus the other law, which I did not quote before for me not to take time, we have the Code of Criminal Procedure under Section 248 plus 1. There is another thing also, so that we come to narrate them.
Yeah.
Yes. Under Section 248 Code of Criminal Procedure.
Okay.
Act 2008 is saying that language and mode of delivering judgment. The judgment in every trial under this act shall be written in English, provide, however, that it may also be written in any other language prevailing in the area, if necessary.
Hey, but this is contradictions, Angelo.
I'm telling you, yeah, this thing is, and that's why I'm saying there's a conflict of law. There's a conflict of law here,
Okay.
which, if we are not very careful, we may end up not implementing what the Constitution is saying. But we have Article 3 of our transitional constitution of South Sudan 2011 as amended, whereby it says that the authority of government at all levels shall derive from this constitution and the law. Yeah, in this case, we see the constitution is the mother law of all laws, and any other laws must conform to the constitution by getting what the constitution is saying, following the constitution, and no any other law should be above the constitution. And the new constitution will address that.
Yeah, I'm getting you very well.
Yeah, the new constitution will address that. As of now, if there is any conflict, there is a conflict of law when you see like that section of Code before section 66 of Civil Procedure Act 2007, you go to section 248 of Code of Criminal Procedure Act 2008. There is a contradiction between the two, but the power of the Constitution prevail over the other one.
Okay,
I think by 2007 we were not a country.
Of course, yes.
By 2008 we were not a country.
Yeah,
we were an autonomous region, get the power from the CP agreement.
Yeah, of course, of course. Angelo, you raise a good point here, and I think law is always contradict, and I think this is what you also narrated, and you have also read them out so that we know. Those of us who are not also informed about the law, we may also acquaint ourselves with this. And South Sudanese, we know that the level of education is really better low, Angelo. And as you can see today, you might be seeing that most of the peoples are not accessing educations. And let's say in South Sudan, the number of literacy in 2020 and 22 was almost 76% of the population. They don't know how to write, they don't know how to speak. Okay, 76%. Let's say 20, 24. These people, you just find them in the cities like Juba, like Malakal, like Wow. You may find these peoples, they know how to speak. Some of them, they know Arabic. And some of them, they know how to write English and Arabic as well. And we have the civil populations down there. They don't even know what to write. They don't even know what to say. But we have peoples who are well informed in Arabic. They know how to speak Arabic because Arabic has been our local language, let me say. Now, what do you say about this? I want to know the logic behind government of South Sudan. And this is the first question I asked before that. What makes South Sudan government to make English language a official language instead of Arabic? Why are they choosing English and not Arabic? And Arabic now is one of the second largest language most people speak about. Okay, but English also is being the first one. So why are they not choosing Arabic also to be? Is it because is it because the Northerners are our enemies, or what? I don't understand this scenario. Can you tell us the reason?
Thank you for that very good question that you have asked as to why South Sudan option for English rather than Arabic, where we gain our independence from them, and why is the Arabic not supposed to be together? According to the according to the history, when South Sudan gained independence from Sudan, at that time there has to be an exception of Arabic language because at that time South Sudan was not having an expert that can go and stand in court, be defending, be whatever. And we have some of our brothers and sisters who went abroad and studied for the purpose of there was a good, not good education, but they managed to go outside and they study, which South Sudan was having mixed plural legal system. Others go and attend their training outside and they come in they attend the training of inquisitorial and acquisitorial. That is where the issue of Arabic come in. But the issue of Arabic, if South Sudan would have implemented the policy being said by the Chief Justice by now, that let the English be an official language, where will you get the expert? You will not get the expert. That's why there was an exception to the issue of use of Arabic in court, in the procedure, and all this. But there will be a time that it will improve, and some people like us can join and can make what the Constitution is saying. So it is our time for us to join when we are done with the law school, as I did not mention before, but I have not yet finished my degree. But next year, inshallah, I may finish and I may join the legal profession. And I have studied by practicing under the Ministry of Justice, and I have done my training under the Ministry of Justice. And when I was in my second year, I'm done with it, thank God, under the Ministry of Justice and Constitutional Affairs. I have gained many experience.
Yeah.
But the problem is the one I have said.
Okay. And Molana Angelo, we have one issue, and thank you so much, because what you said now it makes sense indeed, and that thing is allowing government of South Sudan to choose to make that option. But I really believe in my mind that the only problem that allow South Sudan government to choose Arabic is because of enmity, because they are enemy to Northern Sudan, and they have been fighting for these oppressions. And if they are fighting for this oppression, then they don't need to use the enemy's language. This is the logic, and it is understandable, by the way. And of course, we are now practicing it, and we are trying to get rid out of Arabs. And this is what I'm seeing the South Sudan is doing today. But there is no problem. Since you also say that in court procedure, we should be having Arabic language as one of procedures that should be used. And I believe that I want you to tell us exactly, like if I open a case, مثلا أنا لقيت محامي أنا بتكلم معه, can I talk to him about the stories that happen behind the case and all this, like if the judge, okay, or advocates, if they ask me what happened, then can I explain them in Arabic? Or also if I'm in the court, can I explain them also in Arabic? Then the verdict later on, the final judgments of the court is going to be written in Arabic. It's going to be written in English. Is this what the Chief Justice is saying?
Thank you for that good question. Regarding to what you have said is very good and is very important. And what I can quote by the Chief Justice, let me read the paragraph by paragraph, and let me come into breakdown of what you have asked and what is the saying of the Chief Justice regarding
to that, yes,
to the English,
yes,
and how will it be implemented.
Yes.
Thank you. According to paragraph 1 of a judiciary circular issued by the Chief Justice, paragraph 1 saying all judges in the Republic of South Sudan shall write their judgment in English with effect from the 1st of June 2026. That is paragraph 1. Paragraph 2, the judiciary, with the support of its partners, shall, in collaboration with the School of Law, University of Juba, and other recognized university by higher education, shall exert efforts toward this goal, which bring in the academia like people like us. Paragraph 3 is saying all judges are encouraged to join English language course training with the improvement of the handwriting. Paragraph 4. By the 1st of January 2020, that is what the judicial circular of the Chief Justice is saying. And as I mentioned before, that when there is a conflict of the two laws, the power of the Constitution can prevail. And in regard to you meeting your lawyer, Maslan, let me speak in Arabic.
It's okay.
Maslan, ita قعدت معي بتاعك وتكلمت معه بعربي وشرحت له انا اسالك شنو وبعدك يا لما يسالوك ده من حق بتاعك باي لغه انت داير. لكن there is a dictation said by the law to the judge, not to the victim or the prosecutor or the defense. The one being dictated to write his or her judgment is the judge, which is the presiding judge, the one sitting on the high chair. That is the one being said by the law. You should write your judgment in English. And there will be monitoring of that order, as said by the Chief Justice. And anyone who is not abide by what has been said, the action will be taken further. And the academians, like people like us, will join, and we shall be seeing how far with that implementation so far. Is the English coming into effect or not?
Okay, I think what you say, Angelo, it is really good. And now I've got some point from what you read out. And that circular, I think they are giving trouble to judges. This is what I'm saying. And for the judge, if you don't know both language, you're going to suffer. You're going to suffer a lot. And I think this is where problem will come. Problem is going to come. For example, Molana Angelo, Masalan, I'm coming as a prosecutor. I'm going to open a case. If I open a case, then I need to talk. Okay? يعني في كلمات كده يعني ما بتغير. مثلا أنا أقدر أتكلم مع بالحاجة حصل لي. So you can speak from the heart when you are speaking in Arabic or in your mother tongue. You know that? All these things, the thing that you have in your heart, they will come out. لو قاعد تتكلم عربي جوبة ده. لو even Arabi Sudan ده حاجة ده كله بيطلع. يعني if I'm speaking in English, okay, it can dictate me. Maybe there is something that I may forget, and I will be worried, okay, about how am I going to speak, you know. And if I speak in Arabic, then they maybe azul أنا شاكل له ده هو بسمع, okay, بسمع الحاجات أنا قاعد نقول. Then later on, if we go to the court, then we will go and talk to the judge, the presiding judge. The presiding judge now. مثلا المولانا أنا معه لو شال القضية دي وراه ل presiding judge, okay, لو وراه ل presiding judge بعربيك, and the presiding judge now understand them all, okay, maybe he understood some of the thing, okay, and maybe Zolze is a, okay, let's say somebody who know English, okay, because we are now seeing those who learn Arabic are going to be kicked out. This is the logic. This is what I see. They are not going to be there at all. Let's say those who may know English are the one going to preside over the cases. Then I come as a prosecutor, and maybe ana jay ma Molana tay, okay, ma advocate bitay yalla nene de kaynet kallum barabi naqulu le zolta English de ana zolde amale haja de zolde shal gurush tay de وشال قروش تاعي كده ومال كده ومال كده and all this. Now the presiding judge, being knowing only English, he doesn't know Arabic, okay, هو بكون كيف بيفهم حاجات ده كيف, so that he write the verdicts, because now when you write the verdicts, it means you understood the case, how the case has been initiated from the beginning, and how the case has been moving from the beginning to the end. So you need to write all these things in the verdict. But now you don't understand Arabic, so how will you write the verdict if you don't understand Arabic, Brother Angelo?
Yeah, I think in that scenario, the use of Arabic coming as very important. Like we use it for the mean of interaction in the market and in the other social gathering place. The Arabic is there, but in court, there's a dictation that happened, and the only person that being dictated by law, not us, is the judge. And the judge, when someone appeared in court who does not know the language, either English nor Arabic, you have a right to speak in your mother tongue, but the one can translate what you are saying has to be there prior to, and him or her has to take an oath first that whatever I'm going to be hearing from the prosecutor or the defense or the victim herself or himself, that is what is mean, and I will do it to the best of my knowledge. Has to take an oath first before saying that thing. There's no dictation to the defense, prosecutor, or the victim, or you talking to your lawyer in the language.
Okay.
But the only person being dictated is the judge.
Okay, now, Angelo, let me come to this point. What challenge are you seeing in the background? Let us talk reality. What challenge have you seen in the background? Now, Arabic, I mean, English is going to be an official language, and you're going to write all the cases and all the verdicts in English language. Have you seen some challenge, okay, in the side of defendants and prosecutor or victims? Are you seeing some of the challenge that we are going to face in the court? What are those challenges that you're going to see in the court in case of English language? Thank you.
Yeah, one challenge that I see is that one will not have many experts from English background that will come and write has like the people which when you are shifting from the language to another language is very hard for you. You will have no good expert, and if that circular come into effect on the 1st of January 2027, it will affect many people, and it will affects also many. It will affect many advocates. Let me say, of which there is a dictation. The document that you are submitting to the Chief Justice, that document has to be written in English. The content, the contract you have drafted as what if your client, there is a problem with the contract that you have dropped in the previous days, that thing has being written in English. That is what I mean. And another challenge also is like those graduated from the different university all over the country is that majority of the students don't do in training, which make it difficult because in training you get a lot of things. You financially no support, good support, and if you don't have that kind heart of saying that is what I choose and let me be the way it is, I'm encouraging them for them to join before it is too late, and for you to having the knowledge and do what is called pro bono service also is very good. You get interact with the people, not the money that everything you do that you get the money. No, the other thing that you can do, you don't get money. But what is good is the knowledge that you are gaining.
Yeah, of course.
That is what I need.
Yeah, I've seen this challenge, Angelo, and this challenge are really critical. So we need to inform also the advocates, those who are also graduating from universities, and those who have also graduated since, to make practice, to learn a lot. If you are from Arabic background, you need to learn Arabic. I mean, you need to learn English, know it better, and you need also to know how to write English language for your survival. And I think most of the judges, most of the judges today are surviving in the work that they are doing. And if they are surviving in those work, so they need to be serious. They need to work better hard in order to know English. And later on, when it shifted, 1st of June, then they need to be critical on that thing in order for them to learn English language as a medium language of communication in the courts and all these things. And thank you so
It's
much.
mandatory. It's
Yes.
mandatory. It's mandatory for them to join.
Yeah.
Yeah.
Yeah. I think
Because when you see something being said, mandatory is must,
really.
and action will follow.
Yeah. Okay. We are informing you guys that you need to follow this circular that has been circled by the Chief Justice. The Chief Justice is serious, as we are seeing, and this thing is in the law. We are seeing South Sudan is moving away. South Sudan doesn't need to be an Arabic country. This is what I'm seeing, and this is one of the reasons you see them moving away from these things. You know, when people talk about NCP, they don't like NCP. When people talk about Arabic, they don't like Arabic also. Okay, they like even they shipped away from Arab leagues and all this, but they are now in East Africa, whereby we have joined this, and this is Aruba. They're now moving away from being an Arabic. So thank you so much, Molana Angelo, for giving us.
There is this one I want to add.
Yeah, you added.
In regard to what the parliament
Yes.
is saying concerning the language, before the passing of this recent circular being issued by the Chief Justice, the parliament has a say by under the Conduct of Business Transitional National Legislative Assembly, Conduct of Business Regulation 2011, amended 2021. Under Section 30, is saying, talking about the language. The proceeding and debate in the assembly shall be in English language, and the speaker may allow the use of other translate language, provided that such shall not impair participation of other members in the sitting. Of which there is a dictation also in English to the members of parliament. That is another part in complementing the said by the Chief Justice that English is an official language and shall be used with the effect from the date being mentioned in the circular.
Okay.
That is my heart. This is the copy of the Act of Parliament. I'm not making out of my mind.
So we mean حتى في برلمان زادوا لازم زول يتكلم بإنجليزي والله ده this is too much. Now, thank you so much.
It has to be in English, and for you to stand up and you speak in your mother tongue, there has to be someone translating what you are saying.
Okay.
You speak in Mangaya, any other language.
Yes. Now let us go to second topic, and the second topic we shall discuss is the important questions. Who own the land? Okay, does the land belong to the communities or to the government? This debate has remains one of the most sensitive constitutional and political issues in South Sudan, especially in most conflict periods. Land in South Sudan is not just a property. When we come to South Sudan, and Angelo, you have been knowing this for a long time. Here in South Sudan, owning the land is something that you should be proud of. And owning the lands also, it is all Zolian Zol Ghanian. Bezat fi Juba yene de. Land is connected to culture, history, ancestral identity, farming, also grazing, settlement, resources, and survival itself. So in many communities today, land is traditionally viewed as a communal property inherited through generation, while government often claim authority over the land administrations, investments, and national development projects. And across the different states today and counties levels, we continue to witness dispute over land ownership, displacement, grazing, routes, even urban expansion, and investment lands and community boundaries. All these tensions, they demonstrates why land tenure issue remain is central to the constitution making process in South Sudan. And without clear constitutional understanding, I think land ownership and management, it may become difficult to achieve sustainable peace and also developments and also social stability. We will not achieve them if we don't have a unified constitutional making in order to address all these issues. And I think today this discussion is therefore not simple illegal conversation. I think it is a national conversation about identity, governance, and also inclusion, citizenship, and the future direction of South Sudan. So we are now going to discuss this topic with Angelo, and we want to know exactly, Molana Angelo, according to Constitution of South Sudan, who own the lands exactly? Does the land belong to communities or the land belong to governments? So we want to know this, and we need you also to dig from constitutional backgrounds and on who own the land. We know in many countries, if you go, you may find people, you may find the government having voice in the land. You may find also people having voice in the land. But in South Sudan today, it's quite a bit different. We don't know who own the land and who doesn't own the land. We see communities owning the land, government owning the land, and all this. So I want to know who own the lands exactly in South Sudan's constitution. Thank you.
Yeah, according to our laws of South Sudan, who own the land and what does the law say about it is the constitution is saying that land is owned by the people of South Sudan, and the land has been classified under 3 levels. One, we have under Section 9 of Land Act 2009, talk about the classification of land. All land in South Sudan shall be classified as public, community, and private land. And also we have the hand beneath, which is the land with the subterranean resources. We have the airspace also is the land under the land law. Are you getting me?
Yeah, I'm getting you. Yeah, I'm writing here.
Yes, and then let me go deep into what is community land.
Okay.
What is community land and what is private land, and according to our law. Yeah, public. Let me start with the public land.
Okay.
He's saying that public land is a land owned collectively by all people of Southern Sudan and held in trust by the appropriate level of government. That is what is it saying under clause 1, clause 2. He's saying land lawfully held, used, or occupied by any government ministries, department, or agencies, local authority, except where such land is occupied under private lease. We know what is lease, that you can lease your land out, and the exception to the lease is not more than 99 years. Or you may lease it out at, I think you may not live for 99 years, but due to the name is kind, you can do that.
Okay.
Because in every country there's expectation years.
Okay.
Yes, and then let me come to the community land. Community land under Section 11 of Land Act 2009 shall be held by communities identified on the basis of ethnicity, resident, or interest. That is what is called community land. Private land is any registered land held by any person under a freehold, leasehold, tenure, or any other land that has been declared by law as a private land. That is how the classification of the land. And we see the conflict emerge between this one who own the land, and let's come to the legal background of some other countries and what South Sudan can do as a nation in regard to the ownership of the land, like in the country that is affected by the conflict, South Sudan, and on the process of the constitution making, and through other scholars written about land ownership and what can we do as a country. Let's go to the region. And I don't want to make academic whatever. The work is not mine.
It's okay.
The work belongs to a scholar. Let me quote his name well. The work belongs to Nialchit Mamir.
Yeah, okay.
Who wrote in the book of
Post-conflict.
post-conflict constitution-making dilemmas, an option for South Sudan. The book written by the former Minister of Justice and Constitutional Affairs, Joseph Gengakech, and Charles Manga Fobat. I get some good example that they have illustrated and what can South Sudan do in regard to the ownership of the land and the conflict that South Sudan has experienced. To begin with, there was a conflict that happened to the resident of Matangai, which their home were demolished and they didn't access to proper document. They were settling illegal, and that what can be done actually for such people, of which you cannot be a government. An example, you cannot be a government an employee. You go and sleep in Barkazal and tomorrow you come to work, or you go and sleep in Upper Nile and tomorrow you come to work. There has to be a policy toward the land according to zoning, resident, putting the factories in a certain area, not of this where you and you're walking on the road, you get the petrol station being placed near the road. What if an occurrence of fire outbreak happen? How will it be safe to the public? We need to make awareness on that. And the home were demolished, and as a result, some of them don't have their home up to now, and they are living. Maybe God, maybe God is the one helping them under his shadow. And I think the Central Equatorial Government is supposed to demarcate the land and register the people who were settling before on that piece of land before, and then so that for them they can get access of or owning the land. That is one of the article in Article 28 of our transitional constitution of the Republic of South Sudan, talking about the right to own property. And land is a property, by the way. You can own it. To begin with, compared to our region, which is Kenya, under chapter 7 of the book written by Joseph Gen and the other scholar, this one was under page 134. The people, Kenyan people and the government has list down who own the land and what level. In the Kenya is saying that people of Kenya as a nation can own the land, as communities can own the land, as an individual can own the land.
What does it mean? What does it mean? What does it mean? I think it is in three times now. What does it mean? People owning the land, community owning the land, and individuals owning the land. So what does it mean in that?
Thank you. To bring it down, we have people. Let me start with like people can own the land. Like you, like I can buy the land, which is one of the owning of land, of which transaction has to be done and the changing of the name has to be done in appropriate way paid by the law. And as a company, also group of company or one company can own the land, a piece of land, written in its name, documented, and everything. Also, people owning the land, concerning the resident, people who are there, you can own the land, which is registered, not unregistered.
Okay.
And then coming to communities, we have the right of indigenous community, like people, like the host state that we are living in, which is the Central Equatoria, is the host state that has indigenous people that have been whom their parents, relatives, and all their ancestors were here. They were being buried in that place, and they have right to own that land. And in whatever thing that is happening, there has to be in consultation with them. That is at the community level. Coming to as an individual, like like you, Akol Molana, you can own the piece of land written in your document And you have, as a citizen, you have a right to lease it out, to sell it out, to do mortgage. I think you know mortgage, which is the process of if you want to take the debts in the bank, you can give it, and then that one can be collateral or surety.
Yeah, of course.
That you are called, I've taken this one, and you are going to return this one. And if I fail, this document of mine in regard to the property will be sell out. And
yeah.
And if the money are equivalent,
yes.
And if the money are not equivalent, then I will be subject to the remaining balance. Yeah. And if I have the remaining balance with you,
I have to pay.
Me.
Yes.
Yes. They have to pay you back. That is it. That is how I break it down.
Yeah. Okay. Now, Molana Angelo, you have also compared South Sudan with regions, and that is good enough. And what Niall Titmamir said, I think he didn't bring solution to the contested visions. And I think in South Sudan today, we still have these contested visions. And I thought that government of South Sudan would have also made something in that. And I think this is the visions of Dr. John Garang when he said the land belongs to community. So this thing is still now giving people headache, because why is the land belong to communities and it does not belong to the government? So there is a confusion. If land belong to community, that means communities are the better people who will regulate the land, because the land belongs to them. The land doesn't belong to the government, but it belongs to the communities. So community have the right to make the policy about the land, on how to lease the lands or to sell the lands or to do anything that they want. Now you brought an example of Matangay, people being displaced right there, and is a government of Central Equatoria orchestrating this, and the reason they are doing it is because of that scenario in the constitutions. I mean, what Dr. John Garang said in 2005 about the land belong to community, and I don't know, you did not mention that in the law, in the Constitution of South Sudan. What did Constitution of South Sudan say about that statement from Dr. John Garang, that the land belong to community? What if other community come? Where will they stay? And what does the Constitution say also about the capital city? For example, I'm coming from Bantu. I want to make my house here in Juba, and Juba is already a land. It has its own people, like indigenous, as you said earlier. So if Juba has indigenous peoples, then it means that I have to come and I will find these people there. But there should be a regulations of the land policy. For example, I may have my money and I want to buy a land so that I stay in Juba. Where will I stay if land is not there, if land is not demarcated? So that ana balga land عشان نطلع قروش بتاعي نديله زول عنده أرض. Then he give me the land, I stay in the land. That I own it because I paid for it. That thing, I think there is no regulations in the constitutions. There is no constitutions say that, or maybe it is there and I did not read it. If it is there, what allow Central Equatorial government to displace people from Matangay? If this law is there, so the government of Central Equatoria would have not even bothered themselves to go to Matangay and displace people who have already built the houses and all this. Okay, and I don't know if it is there in Constitution. You need also to justify if this thing is there. Does it mean, another one is that, does it mean I have to come to Juba and I will not stay in a land? Where will I stay? Can I stay in a hotel? Can I also rent place in order for me to stay? Can I? Where can I own the land exactly in the capital city, Molana? I wanted to clarify this. If this thing is there in Constitution, then what allows Central Equatorial government to displace people in Matangay? Thank you.
Yeah, thank you for the very nice question you have asked. And in regard to what does the law say about the ownership of the land? And I can quote according to the Article 170 of our transitional constitution of the Republic of South Sudan, clause 1, clause 2. May I read? All land, clause 1, all land in South Sudan is owned by the people of South Sudan, and its usage shall be regulated by the government in accordance with the provision of this constitution and the law. Clause 2, notwithstanding sub-article 1 above and the provision of Article 28 of this constitution, the government at all levels may expropriate land in the public interest as shall be prescribed by law. In regard to issue of land, how can it be solved? The Constitution also refers to the classification of the land in the Constitution. The land has been divided into three: the public land, community land, and the private land. And one of the things the South Sudanese has emerged in the national dialogue being conducted in the recent years. But I want to quote the said by the Nialchik Mamer in his reference to the issue of land at the national level and how it being discussed, and what point can South Sudan take to equip itself with in the new constitution making? That with Greater Upper Nile Conference, what have they recommended about the issue of the land? The Greater Upper Nile Conference recommended that gazette urban land be owned by the government in a rural be owned by the government in a rural area under the ownership community, except for protected areas such as wildlife and forests. And the Greater Barakazal Conference propose the land should be owned by the government, should be owned by the community. And then the Greater Upper Nile, the Greater Equatoria, I beg your pardon. These two, the Greater Barakazal and the Greater Upper Nile, propose the issue of the land and how can it be done at the national level, and what example can the country take like South Sudan. But all those three regions did not agree in regard to the land. But as an academia, we can rally on what has been said. When each of us people in regard to the right not to be violated, we have to bring in the scholars. What can be done? We have to bring the government, who is going to be the custodian of the regulation of how the land can be regulated. And as I have narrated before, that the government of South Sudan, under the article I mentioned, talk about the regulation of land. Land is owned by the under government is the one to regulate. But what happened in Matanga, if I may say, maybe taken in the context of the politics, but the right of the people who have been settling there has to be respected, and the right of the host state has to be respected, for which the host state can welcome you to give you the full document that you, Mr. X or Y, you have to settle in this place and you can apply to the land of to the housing and land. And the state has to need to have the policy of how demarcation, because Juba is the capital city and is developing rapidly. The population get increased, others come here for the purpose of education, others come here for the purpose of opportunity to work, others come here for the purpose of business, and many other things that make people to be in the capital city. And the state has to align to, when the population is increasing, there has to be a demarcation, and there has to be proper access to the document. But what happened to the resident of Matangai? One, the resident was not being accepted by the host state that they were settling. They are the one who allocate them to that place. That's why their homes were being demolished. And many things happened, shooting and, excavators came and the houses were being demolished, which is in regard, there was a human rights violation in the middle. And the same people also, the government can use them later on in order to get some other things. Like during the upcoming election that is going to come, my house is demolished and you are coming to me saying that you vote for me. How can I vote for you when I don't have the house that I'm living in?
Yes, indeed, yeah, indeed.
Yes. Yes.
Okay.
So that thing needs to be that thing needs to be considered, and we have to respect the right of the host state, and the host state should follow the law. And we, the people coming here for the other business, also should respect the host state. Each and every one of us has a right to own the property, should be in accordance to the law, and the demarcation has to happen. And in regard, like when you see at that resident of Matangai, there were some other crimes that were been happening in issue. Other people, they were not shipped, if I may say. They were not shipped in the origin place that where they come from, but they come and make themselves as sheep, and they wait. Hello.
Yeah, I'm with you.
Other people were not sheep. They make themselves to be sheep here when they reach Central Equatoria. They become there to make their own illegal demarcation of the land. They give the land, and as a result of that, bias happen, fighting happen. You get the one piece of land is having 8 people, and the document is not being issued by Central Equatorial State Government. The document is being issued under the custodian of the chief, and under the power, the chief don't have the right to allocate the land, but the Central Equatoria, which is the host state under Schedule B of our constitution, give the host state a power to demarcate the land, and you have to give the proper document. Many people die in Matangai, by the way, before the demolition happened. And all in all, it was the result of the land. And as a result, I think they said they expect the police decision of demolishing the land. That is what happened.
Now, I have the land. I have the land there in Matangai. And what do you say it is true? Because there are some people who are also having the lands in Matangai, and they are not staying there. So it is the same thing that you said. Indeed, we need to respect ourselves. The host community should also respect people who came from other communities. And also, people who came also from other communities, they need also to respect the host communities. And this is how life move on. But Molana, our constitution has to move straight. Our constitution has to move straight forward in order to give the right to the peoples who came from different places and peoples who have been in the place. So all these things have not been there. And this is what I'm saying. But that is fine. We will just move on like that. Now we are coming to the end of our program. We are 1 hour live. And I want you to give us your general view over the ownership of the land and who should own the land. I think you talked a lot earlier about who should own the lands and in constitutions. But according to you, as Molana, who should own the land so that we end this program? Thank you.
Thank you, my brother Akol, for coming to conclusion of our interview on who should own the land. In my view, as an academic, my point is that let the land be regulated according to the law. Let us respect the right of the indigenous community, which is the host state. Let us respect the constitution, of which you as the host state, when you are doing something, let it not infringe the right of others. under the law and let the government of South Sudan in the new constitution making process regulate on who own the land and get something also in our interview. And I expect that question I would have get it from you under my research that I conduct outside and I did not get it from you.
Okay.
We have the heritage space and the heart beneath, which is the land below the surface. And I expect you would have asked me some question from there. And I was very ready
But
to
I
answer
think
based
I think
on what our law is.
I think it is an advance because Anama bit kalambe ayat folk. Ayat folk de kaliminak, but we are still here down. This
No, I'm saying.
yeah. So you can also add, if it is there in constitution, maybe you can just give us a brief about it.
Yeah, thank you. Land, under let me start with the three type of earth, which is the earth surface and the land below the earth, which is the subterranean subterranean land down the earth. Like our law is having a problem with that. When you look at our constitution, of which we have the hairy space, we have subterranean where the resources live, and the hard surface, that is where we are quarreling in, we have fighting of land, and no need for that. Like when you look at our history as a country, we get our independence in 2011. And recently, in 2024, can you imagine from 2011 up to 2024? All this time, Sudan was the one controlling our health space as a country. And we have been our independent. What are we supposed to train our own to keep on monitoring our hair and everything has to go on in regard to the hair space. But thank God, South Sudan get it independent, and independent is, say, Rome was not built in one day. It took some number of years until it's done where it is today.
Yeah. Okay.
And also, we have the allocation of this one, the who own the land beneath, which is the subterranean where the resources are living. The law also is saying that when there is a resources being covered, like where you are living now, my brother,
yes,
and there's a resource being covered there in the national government. The law is saying that you own the surface, but down you don't own.
Okay.
That thing is not correct. It needs to be correct in the new constitution. That is
okay.
What I'm seeing is a conflict. Yeah, they can say that you're subject to compensation, you can compensate and leave this place. And I have get that thing. I did not whatever. I get it in the place, and maybe the thing happened by natural.
Yes.
I get it like that one. I deserve to get it, the percentage, but something has been covered by the subterranean land, and we as a government we can allocate you somewhere. That thing is not. It's supposed to be like this is being covered under your. When it has been covered land, then the government you can have a right to come control your percentage.
Okay,
but here it's totally different.
Of course.
In regard to that. And the land surface also need to be regulated also. In a regulation like that one of Kenya, I see is very good. You can public land like here in Juba. When demarcation happen, like we have what the land in the land law is saying, there has to be a zoning. One, there has to be a playground. or which children born in that area has to play football. They have to do their whatever exercise there. And in case of if the government is having function or rally, he can go and call those community and have a gathering meeting with them there, another social gathering. And also when the demarcation happens also, let there be a place where police station, because people might be living in the resident and you don't expect something. And there's a police station that will help. Also, there has to be a like when you get one of these, my house cannot be demolished. My house can be demolished, but in accordance with the compensation, you can be compensated for you to go and build another house. There has to be a proper quotation being done, and there has to be somewhere where you are going to be. That thing I needed to happen, and in regard also to some, in regard to place, like in some other place, you can get a water pipe being connected. The electricity, like this of this budget of ours. Other place in Juba don't have that one, but it is one of the right also to have that place. You can get the water being connected in your residence, and you get the goodness of many things. I can say, and thank you for hosting me. Whatever, any whatever branch of government or whatever, we are using them as in our view and what does our law is saying, and we are very helpful that people are watching us and they are listening and look at what analysis they are what can South Sudan and thank you for hosting me. I'm very like anytime you ask me in the other coming event in regard to what is happening, like issue to do with the law, I'm free. I can give a legal advice as I have get a request from you that you should need this me the historical and my father.
Okay. Okay. Thank you. Thank you so much, Molana. We really thank you so much for coming, and this is a good thing indeed. Bringing you live here was really good, and we have discussed a lot of things, and we have got many things from you, like who owned the lands and English language being an official language, as Chief Justice circular it. So we need to say that. Thank you so much for following Akol Podcast. And my brother Molana Luol, he has been saying a lot of things, and he has been showing you also the books so that you see